Council, we have some time here at the end of the day. We had some cleanup matters as far as exhibits, and some that were provisionally offered and some that were, I think everybody assumed were offered. Mr. Frank, anything you'd like to do to clean that up, or?
Sure, Your Honor. Are you going to stay here, or am I back close enough to the microphone?
You're close enough to that microphone, and it is on, so.
Your Honor, we have a number of questions regarding exhibits, and I think we can deal with them on the record at this time. Your Honor, we understand that Exhibit 15, the record may reflect it had been conditionally offered through Donald Williams because Ms. Frazier was going to testify later. If it was not made clear that that was then being formally offered, sufficient foundation was certainly laid for that during Ms. Frazier's testimony, so we would ask that Exhibit 15 be formally offered at this time and received.
Any objection to that, Mr. Nelson?
Your Honor.
It is formally received.
And Your Honor, we had Exhibits 922 through 951, slides that were used during Dr. Tobin's testimony, and we just want to be clear that the record reflects we are agreeing that those should be considered only as demonstrative exhibits and should not then go back to the jury as substantive exhibits.
Agreed, Mr. Nelson?
Agreed.
It did appear that they were demonstrative at the time, even though it was not specifically stated, so we'll change the status of those to demonstrative only. It will not go back to the jury.
And Your Honor, during Dr. Smock's testimony, there was reference to a demonstrative about the signs of excited delirium. That may have been referenced as 921, may have been referenced as 941, when it was actually 921. 941 obviously falls within the exhibits we just talked about as demonstrative. So that, we believe, should be marked as 921. We understand that that's a demonstrative anyway and would not go back to the jury.
Is that correct?
I'm not doubting Mr. Frank.
So one more time, Mr. Frank, 941 should actually be 921?
I think it may have just been referenced during court as 941. We have it marked as 921, and it's a demonstrative either way.
All right. So, Mr. Schaefer, how do you have it?
That's the 10 signs of excited delirium.
Correct.
Yeah, I had it in the record as 941.
All right, leave it as 941? Demonstrative only, or did you want?
So then there would be two 941s. So
correct.
It should be 921.
So the slide deck on excited delirium, which was marked and received as 941 for demonstrative purposes only, should be remarked as 921 for demonstrative purposes only.
Correct.
I believe that's correct, Your Honor.
All right, so ordered.
And Your Honor, during the testimony of Chief Arredondo, there was reference made to Exhibit 269, which was the map of the Minneapolis precincts. Our records show that that was offered and received, but maybe some question about that. So at this time, we are formally offering 269.
Any objection to that? That's the colored precinct map, is that correct?
Right.
No objection.
269 is formally received. Can we return back to 9? I forgot what we finally marked it as. The excited delirium slide deck. 921. I think the record should reflect we had a chambers conference about redaction of that before it was given to the jury.
No, that's a different one, Your Honor.
Right.
Okay. I'll wait for you guys, and I'll speak when you speak to it. Because we did have a chambers discussion on a redaction.
That will be 1,053-ish, but we'll come back to that, if we can.
Sure.
Okay. Your Honor, Exhibit 110, which is one of the Minneapolis Police Department Defense Policies Training Guide. We indicate it was offered and received during Lieutenant Mersel's testimony, but there may be some question about that. So just to clarify for the record, we are formally offering 110.
One moment, Your Honor.
And that was, again, your description?
It's the Defense and Control Response Training Guide.
No objection.
All right, 110 is formally received.
Your Honor, Exhibit 255, we indicate that it was offered and received during Sergeant Steiger's testimony, but again, there may be a question about whether that was actually done, and so we would just formally offer 255 at this time.
Mr. Nelson?
155.
255? And what's the description of that again, Mr. Frank?
It is a screenshot from King's body-worn camera at 8/19/35.
That's one I don't have a copy of. 255, I don't have a copy of that one, counsel.
255?
And it was at what time?
8/19/35.
So 2019, 35.
Correct.
You have that it was offered and received, but the court doesn't, right?
Correct.
Yes, no objection.
All right, 255 is received if it was not before.
And Your Honor, Exhibit 122, which our records identify as the MPD Crisis Intervention Training PowerPoint, we believe was referenced, may not have been formally offered, but we would offer it this time.
Can I have a moment to chat?
Sure. And the number again, Mr. Frank?
Your Honor, upon further review, we would withdraw Exhibit 122.
All right, 122 is withdrawn.
Your Honor, then, just for clarification of the record, if it's necessary, Exhibits 624 and 628 were just only used to refresh recollection, not offered as exhibits.
Understood. Marked but not offered or received.
I believe that clears up the rest of the questions.
Those were just offered to refresh recollection. You said they were never offered formally.
Correct.
Mr. Schaefer, anything else that, any other loose ends?
No, I think we have it, but can I get the inclusive number of the demonstrative from Dr. Chauvin? Did you say it was 922 through 951?
922 through 951.
Okay. Are we ready to talk about the milestone camera and the player?
Yeah, that was the next thing on our list.
Mr. Nelson?
So, Your Honor, our request was that the milestone video that was introduced, I believe as exhibit, that the state introduced as exhibit number 11, which was the milestone video in its entirety, but it was cropped and excerpted, meaning it was not the entire 3 hours or whatever. It is the defense position that we don't have an objection to that being excerpted as far as the length of the time. However, it's our position that the actual evidence in the case would include the player for the milestone as opposed to a recorded version of it. The reason is, Your Honor, when when that exhibit was demonstrated or played, published in court, it appeared to be very choppy. It appeared to be at a reduced period of time. I don't know if that was simply a computer problem or some technology problem. When I look at it on my computer, I see the same choppy thing, choppiness to it. The milestone player, as was testified to by Lieutenant Rubel, specifically allows the camera to zoom in, zoom out, be manipulated. You can see that in the video, the user of the video is actually doing that at times because the cameras can be moved. That's the actual exhibit, and it allows the jury to interpret that video accordingly. The submission that was conditionally accepted is not the actual exhibit. It's not the best evidence.
Mr. Frank?
Thank you, Your Honor. I'm not quite sure what best evidence rule is to do, but let me just say it this way.
I think he was using it as a phrase and not the rule.
Yeah, probably. I guess.
Say again?
Not sure anybody really knows what the best evidence rule means anymore, so I'll move on. Your Honor, we offered Exhibit 11 for a specific purpose, and that was for the 911 operator, Jenna Scurry. It was cropped because the Speedway sign occupies a big corner of that video. And so that's why it was offered as Exhibit 11. We offered, and the court received Exhibit 42 through Lieutenant Rugel. That was the milestone video of about 49 minutes long. That is the full video. It has the Speedway sign. It's from the time that Mr. Floyd is at the store to the fire truck leaves. That's the full video that we intend to offer. It plays we still believe that the slight catching of the video was just simply a computer issue at that time and getting it to load and play. Before we send the exhibits back to the jury, we'll of course make sure that it plays at its normal speed. But that's the actual video, and that's all we intend to offer. It plays, and that's all we intend to offer.
Is 11 a subpart of 42?
Correct. And I apologize, Your Honor, I was referring to the wrong exhibits. But yes, 11 is a condensed, excerpted, and cropped version of 42.
So we're just talking about whether the player should go back for 42.
With the same length of time, and that would be our position, yes.
How did Lieutenant Rugel play it when he was testifying?
Your Honor, we had an offer of proof with Lieutenant Rugel, where when it was originally played, the jury went out and I showed how it would actually work with the player.
So, what's the state's position about sending the player back?
Your Honor, I think the jury should receive the video itself and not be given the player so that they can zoom in and zoom out. They should have the evidence that is the video and not the player. That's our position.
Mr. Nelson?
It's not the milestone video without the player. And so, again, it's within the province of the jury. They may not use that feature. I mean, it is the evidence.
It is the video. We laid a foundation for it through an expert who works in the field. It's the video itself.
All right. If you've tested it out on the computer that's going back to the jury and it plays smoothly, I'm going to deny the request to send the player with because the tools of the milestone video player were not used as part of testimony, and the evidence itself is the video. And so to allow the zoom and other features were not really offered as part, and so but if it's choppy, the player's going back. Pure and simple. Because they have to have a way to play what is, as the state says, the evidence, and that is the video. Can't be choppy, can't be a different speed. It's got to be real time, going ahead with the player or not. So let's make sure that happens, and if the state can make sure you represent back to the court that it is in working order. and I'll assume it is, but please verify that you've done the testing.
We will.
Thank you. Anything else that we have to clean up? Mr. Slisher?
If I may, council indicated in the bench conference today that he has a motion that he wants to make. He wants to address that.
Oh, yes. We went immediately from the state resting into the defense case. I had assured Mr. Nelson off the record to maximize the jury's time that he could reserve his motion until we had a break when the jury was not present. Accordingly, any motions he makes as far as the judgment of acquittal are timely, and they're just being memorialized at this time. Mr. Nelson?
If we could take that up tomorrow morning, perhaps come a little bit before the other hearing.
Let's do 8:45. We should be able to do most of this. All right, we'll take that up tomorrow. Any other motions? I did want to memorialize, I think you said it was 1053 was the exhibit, the excited delirium slide deck. Is that correct?
Correct. I believe it's, let me just double check here.
In any case, we had a chambers conference at the state's request to talk about redactions, and I did order redacted one picture out of that because it was not relevant, and given the very limited purpose for which it was offered, deleted the picture that showed someone being restrained in the prone position with a knee on the neck. It was not part of the excited delirium presentation. It was just coincidental with some of the facts we might have here. So that photo was redacted, and also there was a list of references of the last slide that was deleted because we don't want to have the jury look at that and then decide to do some internet research. Not that they would have the tools back there, but in deliberation, but nevertheless. So those are the redactions that I was aware of. Is that correct?
And I completed those redactions over the lunch hour. I provided a copy to the state.
All right, now we'll receive that redacted version as Exhibit 1053. I think that was all the bench sidebars that we were not that were substantive. Everything else seemed to be non-substantive scheduling. Anything else that we have to make a record of before tomorrow?
Your Honor, we have been just taking notes of bench conferences throughout the course of the trial.
Sure.
And in terms of some of the bench conferences, at least from our position, and not expecting the state to respond to these immediately, but in terms, I just want to memorialize some of the conferences that we've had either in chambers or at sidebar. Your Honor, it is based upon our recollection that on March 30th of 2021, in a morning chambers meeting, in terms of the adolescent witnesses who testified that the court directed the state to lead the younger witnesses, gave them permission to lead the witnesses. That was all within the context of the discussion about whether they would be videoed and audioed and things of that nature. With respect to Mr. Williams's testimony, there was a sidebar where the defense objected, I think you sustained the objection as to Mr. Williams being a security expert. Just wanted to note that that was the substance of that sidebar. At sidebar, a second sidebar, there was a defense objection as a repetitious questions about Mr. Williams feeling that Mr. Floyd was in danger. The defense objected to that.
May I make a suggestion, Your Honor? If we could maybe shorten this up, perhaps email us summaries of bench conferences, we can take a look and then have something that we agree to that we're able to present to you tomorrow.
I think that's reasonable. We'll get that sent out tonight.
All right.
Just one last thing, Your Honor. In terms of just, as the court is aware, there's been ongoing disclosures that have been going on throughout the course of this case. And I think we could probably have a chambers conference regarding a couple of things if the court would be so inclined. But as based on my records, at the point that this trial started, we had received 29 disclosures totaling 45,118 bait stamps items. As of yesterday's date, we were up to 41 disclosures totaling 50,272 disclosures. There have been some discussions, and I know that there have been more disclosures that have come in since. Some of these disclosures involve potential impeachment materials of expert witnesses and things of that nature, and they are quite voluminous. And so if we could have a discussion about what, if any, of these materials the state would intend to impeach with, that would potentially be helpful. I think we're up to, as of yesterday, we were at 50,272. So it would be very helpful to help have a meaningful opportunity, for me to have a meaningful opportunity to review those between now and tomorrow, when I expect a couple of experts to testify.
Are these related to your experts?
I believe a significant portion of it is.
All right, since the disclosure is fairly late, I'm not saying untimely, I'm saying, but it is late in the game. I would ask that the state meet with Mr. Nelson and kind of indicate what it is you're planning on impeaching with.
Your Honor, we continue to be of the position that those are matters we have actually no duty to disclose, other than the court's order in this case that we do them. Of course, that order was made at a time recently, and we have been disclosing those things that we had, and that as we continue to get, of course, as we prepare for these witnesses. They may never be used, but their potential for impeachment, the court ordered us to disclose them, so we're doing that.
Right.
Now, to further ask us to tell counsel what we're going to use to impeach, it's a little difficult to do before you hear the testimony.
Well, I could continue the trial, so give them time to prepare.
I don't see a need to do that, Your Honor.
I think that this is my point. I'm not saying the state is acting in bad faith, not at all. These things are moving targets. But when we are actually in trial on the eve of Mr. Nelson calling these witnesses, and I would not restrict you to what you could impeach with. I'm just saying what you will use to impeach these witnesses, if you could at least highlight those, reserving the right to put other things in. Because I'm sure there's stuff that right now you know what you're going to use to impeach. Other things maybe, maybe not. The maybe, maybe nots, I'm fine with you just waiting. But if you know there are things you're going to impeach with, I think it is appropriate, given the fact that these are being disclosed late in the game, again, not making any accusation of impropriety, just they are late in the game. I don't want to have to give Mr. Nelson a continuance and have the jury sit around to give him an appropriate amount of time to prepare. What I'm saying is it gets us to putting these witnesses in front of the jury quicker if we just work together on highlighting things. So I am ordering the state to at least what they know for sure they're going to impeach with.
Understood, Your Honor. We'll do what we can.
All right. I appreciate that. Okay. Anything else for the record? I do need to talk to you in chambers about an issue that relates to security.
Wait.
Security, everybody. I need counsel. Just counsel. All right. Thank you. We are adjourned for the day then. Let's get back at 8:45 tomorrow for the other issues.